You have 30 seconds to walk out that door, or I drag you out myself." The hand on her arm tightens, fingers pressing into the fabric of her gray cardigan, bunching the wool, telegraphing exactly what comes next if she resists. "I'm not resisting." Her voice stays level, measured, the kind of calm that takes decades to build. "I'm complying with your order, Sergeant." "Then move faster." She moves. 1 step, 2. The marble floor of the courthouse lobby stretches toward the glass doors ahead, 50 feet of fluorescent light and institutional indifference. Behind her, the courtroom she was just removed from continues without pause. The next case already being called. The next defendant already stepping forward. Assembly line justice grinding on. The sergeant's badge catches the light. P4471. She files the number away. A clerk watches from the information desk, arms crossed, slight smile pulling at the corner of her mouth. Above them both, a security camera blinks red. Recording everything. Patient. Indifferent. "Dispatch, this is Pace." The sergeant keys his radio without breaking stride. "Situation resolved. Disruptive litigant escorted from courtroom 3B. No further assistance required." The radio crackles back. A woman's voice, flat with routine. "Copy that, P4471, logged at 0952, incident number 7428. Incident number. She's an incident now, a number in a log that will be filed and forgotten by lunch. They reach the doors, glass and aluminum. The sergeant's reflection walks beside her own, his bulk, her stillness. The automatic sensor triggers. Morning air rushes in, warm and thick with Georgia humidity. "I am leaving." She stops at the threshold, turns, looks directly at his badge, then his face. "But you will remember this moment, Sergeant." He laughs, short, sharp, the sound of a man who has heard every variation of that threat and watched every variation walk away defeated. "Sure I will, ma'am. Have a nice day." The doors close behind her. She stands on the courthouse steps, sunlight falling across her shoulders, and begins composing the complaint she will file within the hour. The first domino in a cascade that will reach the highest levels of judicial oversight in the country. But she doesn't know that yet. Neither does the sergeant already walking back to his post. Neither does the judge still laughing at his own joke in courtroom 3B. The only thing certain in this moment is the security camera above the entrance, blinking red, recording a black woman in a gray cardigan walking down courthouse steps alone. No one watching the footage would guess what happens next. If you think you know where this is going, you're wrong. Stay with me. 4 hours earlier, Vivian Marlowe stands in her kitchen watching coffee drip into a ceramic mug. The house is quiet, has been quiet for 3 years now, since Marcus passed, since the funeral flowers wilted, since the condolence cards stopped arriving. She's made peace with the silence, filled it with work, with purpose, with the kind of discipline that doesn't require company. On the counter beside the coffee maker, a traffic citation sits in a plain manila folder. 3 weeks old. Red light camera at the intersection of Peachtree and 5th. $287. She could have had her assistant handle it. 1 phone call, 1 piece of official letterhead. The citation would disappear into administrative grace, and no one would question why. But that wasn't the point. She picks up the citation, studies the grainy photograph. Her sedan, captured mid-intersection, the light a red smear above. The timestamp reads 11:47 p.m. She'd been driving home from a community center event, running late, distracted by the speech she'd just given to a room full of law students who had no idea who was speaking to them. The letter accompanying the citation is form-generated, impersonal. Failure to obey traffic control device, pursuant to Georgia Code Section 40 to 620. Payment or court appearance required within 30 days. Court appearance. She folds the citation precisely, edges aligned, creases sharp, and slides it back into the folder. No letterhead, no embossing, just documents. The coffee finishes brewing. She pours, takes a sip, checks the clock on the microwave. 6:14 a.m. Her docket at the court is clear today. A rare gap between case reviews, a window she'd blocked weeks ago for exactly this purpose. She'd told her clerks she had personal business. They hadn't asked questions. She carries her coffee to the bedroom, opens the closet, passes the rows of dark suits, the pressed blouses, the judicial robes hanging in their garment bags, reaches instead for the gray cardigan, soft wool, 3 years old, bought at a department store sale. Simple earrings, flat shoes comfortable enough for standing in line. Today she's not a justice. Today she's a citizen with a traffic ticket, appearing pro se in municipal court like thousands of other Americans who can't afford attorneys for minor violations. She dresses methodically, each choice deliberate, each layer a kind of costume. The ordinary woman she might have been if different doors had opened, different paths had unfolded. By 6:45, she's in her car. An older sedan, not luxury, not flashy. The kind of car that doesn't attract attention in parking lots or traffic stops. She'd kept it after Marcus died, even though colleagues suggested something more befitting her position. She'd ignored them. The car still ran. That was enough. The radio plays NPR as she drives. Traffic light. The city waking around her. The traffic citation folder sits on the passenger seat. Beside it, 3 additional documents she'd prepared last night. Calibration records, maintenance logs, a photograph of the intersection showing the misaligned sensor loop. Evidence. For a $287 ticket, most people would just pay it. Accept the fine. Move on. But most people hadn't spent 40 years watching how systems work and how they fail, how small injustices compound into large ones, how the people with the least power bear the highest costs, while the people with the most power never see the inside of a courtroom. Today, she would see. The Marlow County Courthouse sits at the edge of downtown, a 3-story concrete block built in the 1970s and renovated never. The parking lot is already half full at 7:45. Attorneys in dark suits, clerks carrying coffee, citizens clutching paperwork and checking their phones for the courtroom number they'd been assigned. Vivian pulls into the first available space. A sign nearby reads, "Attorney and court personnel parking only." She's barely out of the car when a parking attendant approaches. Young, bored, clipboard tucked under his arm. "Ma'am, this lot's for attorneys and court personnel." He gestures vaguely toward the back of the building. "Public parking's around back, overflow on Maple Street. I'm appearing pro se today, representing myself. That should qualify." The attendant looks at her car, looks at her. The calculation visible in his face. This car, these clothes, this woman using terms like pro se. None of it matches whatever image he'd constructed of people who belong in this lot. "Fine." He tears a ticket stub from his clipboard. "But if you get towed, that's on you." She takes the stub, says nothing, files the interaction away. First data point. The walk to the courthouse entrance is 200 feet of cracked pavement and faded directional signs. Other people pass her, some walking faster, some slower, all wearing the particular expression of citizens summoned to interact with systems they'd rather avoid. At the entrance, a metal detector and 2 security officers. The line moves slowly. People emptying pockets, removing belts, placing bags on the conveyor. When Vivian reaches the front, she places her bag on the belt without being asked, removes her watch, walks through the detector. It doesn't beep. The officer on the other side waves a handheld wand over her anyway. Thorough, slow, taking his time in a way that feels less like procedure and more like performance. Purpose of visit? Traffic court, courtroom 3B. You got representation? Myself. The officer's eyebrows rise. A small smirk crosses his face before he can suppress it. Good luck with that. Briggs doesn't go easy on walk-ins. She collects her belongings, notes his name badge, Officer Randall, notes his tone, not hostile, just dismissive. The casual assumption that she doesn't belong here, doesn't understand how this works, will leave defeated like everyone else who tries to fight the system without the credentials the system demands. Second data point. The hallway beyond security is institutional beige, worn carpet, flickering fluorescent lights, bulletin boards covered with outdated notices. She passes a directory and finds courtroom 3B listed on the second floor. The elevator is out of service. A handwritten sign taped to the doors. Use stairs. Maintenance in progress. She takes the stairs. Counts the steps. Notices the worn treads, the scuffed walls, the particular smell of old buildings that haven't been properly ventilated in decades. Budget cuts made visible. Services deferred. The physical infrastructure of justice crumbling one postponed repair at a time. Courtroom 3B is at the end of the second-floor hallway. The door is closed. A sign reads, Traffic Court, Judge Coleman Briggs presiding. No cell phones, no food or beverages, no disruptions. She checks her watch. 8:17 a.m. Her case is scheduled for 9:30. The waiting area outside the courtroom is a row of plastic chairs bolted to the floor. Half are already occupied. A young woman with a toddler squirming on her lap, an elderly man with a cane resting against his knee, two teenagers in school uniforms whispering to each other. All here for minor violations, all waiting for their 3 minutes with the judge. She takes a seat at the end of the row, opens her folder, reviews her documents one more time. The courtroom door opens. A woman emerges, deputy clerk, based on the badge clipped to her blazer. Mid-30s, hair pulled back tight, the expression of someone who processes 500 cases a week and has stopped seeing individual faces. Henderson, Martinez, Johnson. The clerk's voice carries that particular flatness of routine. First block. Front 2 rows inside. Everyone else, wait until called. 3 people stand. People gather their papers, file into the courtroom. The door closes behind them. Vivian waits. 8:45. The clerk reappears. Nguyen, Washington, Patterson. The elderly man with the cane struggles to stand. Vivian watches him balance on the cane, one hand reaching for the chair back. No one offers help. He makes it upright on his own, joins the small group entering the courtroom. The door closes. 8:52. Vivian approaches the clerk's desk positioned beside the courtroom door. Excuse me, I'm Marlowe. Vivian Marlowe. I'm on the 9:30 docket. The clerk doesn't look up, scrolls through her tablet with one finger. Marlowe, red light violation. Intersection of Peachtree and 5th. That's correct. You're moved to 11:15. Sit in the back until called. The notice specified 9:30. Now the clerk looks up. Something flickers in her eyes. Not hostility exactly, more like the particular irritation reserved for people who don't understand how things work around here. Schedule changed. Court's discretion. Sit in the back. Was I notified of this change? You're being notified now. The clerk's finger taps her tablet, closing whatever screen displayed Vivian's information. Ma'am, I have 47 cases on this docket. You can wait until 11:15, or you can forfeit and pay the fine online. Your choice. Vivian holds the woman's gaze for a moment, studies her badge, Margot Stiles, deputy clerk. I'll wait. She returns to the plastic chairs, takes a seat in the back row, notes the pattern already forming, her name called later than scheduled, no notification, the casual assumption that her time holds no value, other names being called out of sequence, the system working exactly as designed for those who designed it. Third data point. She opens her notepad, writes in precise script. Case rescheduled without notice. Clerk Stiles. Possible selective docket manipulation. Document pattern if observed in other minority pro se litigants. The door opens again, another batch of names called, another batch of citizens shuffled into the machine. Vivian folds her hands over the notepad, settles into wait. And watch. The next 90 minutes become a master class in institutional efficiency. From her seat in the back row of the waiting area, Vivian can hear fragments of what happens inside courtroom 3B. The door opens and closes every 15 minutes. Batches of litigants emerge, some relieved, some angry, most wearing the particular numbness of people who've just been processed by a system that never saw them as individuals. At 9:20, she enters the courtroom herself, takes a seat in the gallery, observes. Judge Coleman Briggs presides from an elevated bench at the front of the room, mid-60s, gray hair cropped short, reading glasses perched on his nose. The particular posture of a man who has occupied this position for so long, he's forgotten what it felt like to earn respect rather than demand it. The pattern crystallizes within minutes. Defendants with attorneys receive 4 to 5 minutes each. Their cases proceed with a certain rhythm. Attorney speaks, judge asks brief questions, negotiation happens in the language of plea deals and reduced fines, professional courtesy exchanged, outcomes predetermined but dressed in the appearance of due process. Defendants appearing pro se, representing themselves, receive 2 minutes, sometimes less. Vivian watches a middle-aged black man approach the podium. His citation is for speeding. He holds a manila folder, similar to hers. Your Honor, I have photographs showing the speed camera was positioned incorrectly. Sir, Briggs's voice cuts him off. This court doesn't have time for conspiracy theories about camera placement. It's not a conspiracy, Your Honor. The sign says 35, but the camera is calibrated for 25. I have the documentation. Guilty, $240. Pay at the window. Next. But I haven't had the chance to... I said next. Briggs waves his hand. Theatrical, dismissive. Bailiff, if this gentleman isn't seated in 5 seconds, remove him from my courtroom. The man sits, shoulders slumped. Whatever evidence he'd prepared to present remains in his folder, unseen and unchallenged. The pattern continues. A young Hispanic woman tries to explain that she was avoiding an accident when she ran the red light. Briggs interrupts her mid-sentence. Guilty. $300. A white man in a golf shirt explains the same circumstance. Different intersection, same type of violation. Briggs listens, asks questions, reduces the fine to $150. Understandable under the circumstances. Try to be more careful. Vivian writes in her notepad, disparate treatment visible. Time allocated correlates with race presentation. White male received extended hearing time, reduced penalty. Black male and Hispanic female denied opportunity to present evidence. Sample size small, but pattern consistent with complaint data. She underlines the last sentence. Rosa Delgado's 43 documented cases. The complaints that disappeared into Felix Vance's filing system. The numbers that would eventually reach Inspector Cross's desk. But that's weeks away. Today, she's just a citizen in the back row, watching justice dispensed in 3-minute increments to people who don't have the luxury of being heard. 11:14 a.m. Marlowe, Vivian Marlowe. Red light camera violation. She stands, gathers her folder, walks to the podium at the front of the courtroom. Judge Briggs is reviewing something on his desk. Doesn't look up. Marlowe, red light. Intersection of Peachtree and 5th. How do you plead? Not guilty, Your Honor. I'd like to present evidence. Now he looks up, studies her for the first time. The gray cardigan, the simple earrings, the manila folder in her hands, thicker than most pro se litigants bring, organized with colored tabs marking different sections. Something flickers in his expression. Not concern. Curiosity, maybe, or annoyance at the prospect of a defendant who might actually require effort. Evidence. He leans back in his chair. Of course you would. He gestures toward the prosecution table, where a young man in an expensive suit sits with a thin file. Assistant City Attorney, based on his badge. Mr. Lawson, is the city prepared to indulge this? The young man, Lawson, stands, adjusts his tie. Your Honor, the photographic evidence from the traffic camera is self-explanatory. The defendant's vehicle entered the intersection 0.3 seconds after the light turned red. State v. Morrison establishes that camera evidence creates a rebuttable presumption of violation. Rebuttable presumption. Vivian's voice carries clearly in the courtroom. Exactly. I'm here to rebut. Briggs's eyes narrow. You have 60 seconds. She opens her folder, removes the first document. Your Honor, I'd like to enter 3 items into evidence. First, the manufacturer's calibration specifications for the Redflex camera system installed at that intersection. She holds up the document. Briggs doesn't reach for it. Second, the county's own maintenance logs showing the camera was last calibrated 14 months ago, outside the 12-month requirement specified in Georgia Department of Transportation Administrative Rule 672-10-01, subsection C. Ms. Marlowe. Third, a photograph of the intersection showing the stop line is positioned incorrectly relative to the sensor loop, creating a 3-foot margin of error that exceeds the 0.3-second differential alleged in my citation. She sets all 3 documents on the podium. Organized, visible. The kind of preparation that rarely walks into traffic court without a law degree attached. The camera evidence is unreliable, Your Honor. Under the county's own standards, devices exceeding calibration intervals are presumed unreliable for evidentiary purposes. I'm not asking you to take my word for it. I'm asking you to apply the rules your own jurisdiction established. Silence in the courtroom. The elderly man with the cane, Mr. Patterson, she remembers from the clerk's list, leans forward in the gallery. The young mother stops fidgeting with her toddler. Even Lawson looks uncertain, his confident posture shifting as he glances between Vivian and the judge. Briggs removes his reading glasses, sets them on the bench with a deliberate click. Ms. Marlowe, this is traffic court. He pauses, lets the words hang. Not the Supreme Court. He laughs at his own joke. A few people in the gallery laugh too, nervous, reflexive, the kind of laughter that comes from wanting to be on the winning side of a power imbalance. I'm aware of what court this is, Your Honor. Vivian's voice doesn't waver. I'm also aware that due process applies equally in all courts. The 14th Amendment doesn't have a small claims exception. The laughter stops. Briggs's face shifts, the amusement hardening into something else. He's had people challenge him before, but not like this. Not with citations. Not with the particular kind of certainty that comes from knowing the law better than the person sitting on the bench. Due process. He shakes his head. Due process, she says. He looks at Lawson. Mr. Lawson, do you have any response to this presentation? Lawson clears his throat. Your Honor, the defendant's documents appear to be printed from the internet. We have no way to authenticate their accuracy or chain of custody. Additionally, State v. Morrison requires expert testimony to rebut camera evidence, not just printed documents. The documents are from the Georgia Department of Transportation's official website and the county's own public records portal. Vivian's response comes immediately. I can provide the URLs for verification. As for authentication, Georgia Evidence Code 249901 allows self-authentication of government publications. No expert testimony required for administrative records. Mr. Lawson is conflating evidentiary standards. Lawson's mouth opens, closes. He looks at Briggs, the look of a man who expected a routine case and just walked into something else entirely. Your Honor, that's enough. The word echoes off the walls. Briggs's face has reddened, his hand flat on the bench. Miss Marlowe, I'm going to give you some free legal advice. He stands, not procedure, not normal. Judges don't typically stand to address traffic defendants, but Briggs stands, and the gesture carries the weight of 22 years of unchallenged authority. Knowing big words doesn't make you a lawyer. Printing things from the internet doesn't make you an expert. This is my courtroom, and I decide what evidence is relevant. Your evidence is not relevant. Your citations are not persuasive. Your attitude is not helping your case. He sits, picks up his gavel. Case decided. Guilty. $287. Pay at the window. We're done here. Your Honor, I'd like to note my objection for appeal purposes. The gavel freezes mid-swing. You'd like to? His voice rises. You'd like to? He laughs again. Louder this time. Theatrical. Playing to the gallery. Ms. Stiles, note for the record that the defendant would like to do many things. He turns to the clerk, who's watching with a carefully blank expression. Unfortunately, what she's going to do is pay her fine and leave my courtroom immediately. I'm entitled to note my objection under Georgia Code 151110. Vivian hasn't moved from the podium. Her voice remains steady. Her documents remain on the surface in front of her, untouched by anyone but her. Sergeant Pace? Briggs doesn't look at her, looks instead at the security officer stationed by the door. Please escort this woman out of my courtroom. She's disrupting proceedings. The sergeant is already moving, already walking up the center aisle, already reaching for her arm. I'm not resisting. She gathers her documents, places them carefully back in the folder. I'm complying with your order. The sergeant's hand closes on her upper arm anyway. Let's go. She walks, doesn't pull away, doesn't struggle, doesn't give them anything they could later call resistance. Behind her, Briggs's voice carries, "Next case, Ramirez, Orlando. Failure to yield." The courtroom door closes behind her. That clip of the judge laughing? It's going to come back to haunt him. And this is just the beginning. The hallway outside courtroom 3B is empty, except for a water fountain and a bench bolted to the wall. Sergeant Pace doesn't release her arm until they're 20 feet from the courtroom door. You people! He shakes his head. You think you can come in here with your internet law degrees and waste everyone's time. I wasn't wasting anyone's time, Sergeant. I was attempting to present evidence in my defense. You were disrupting court. By citing the applicable statutes? He stops, turns, looks at her with something that might be curiosity or might be contempt. Hard to tell the difference when they wear the same expression. Lady, I've been doing this job for 18 years. I've seen hundreds of people like you. They all think they're special. They all think the rules don't apply to them. They all walk out of here exactly the same way. How's that? Paying the fine. She holds his gaze. I'm not paying the fine, Sergeant. I'm filing an appeal and a complaint, he laughs. The same laugh as before. The same laugh as Briggs. Complaint. He shakes his head. Sure. You do that. Fill out the form. Wait 90 days. Get the letter that says unfounded and no action taken. That's how complaints work around here. I'm aware of how complaints work around here. Something in her tone makes him pause, just for a moment, just long enough for doubt to flicker across his face before he suppresses it. Elevators that way. Stairs if you can't wait. He walks back toward the courtroom. Doesn't look back. She watches him go. Notes his badge number again. P4471. Notes the way his radio sits on his shoulder. Notes the body camera clipped to his vest. The light that should be blinking green, indicating it's recording, but isn't. His camera is off. She files that away too. The walk to the lobby takes 2 minutes. Down the stairs, the elevator still out of service. Through the security checkpoint, where Officer Randall is processing another line of citizens. He doesn't acknowledge her. She doesn't acknowledge him. The glass doors open. Morning air rushes in. She steps outside, into sunlight, into the particular freedom of someone who has just been shown exactly how the system works, and exactly where it breaks. The county administrative building sits 3 blocks from the courthouse. Same architectural era, same institutional indifference. Different function. This is where complaints go to die. The Office of Judicial Complaints occupies a corner of the 2nd floor, between Human Resources and the tax assessor. The door is unmarked, easy to miss if you don't know what you're looking for. Vivian knows. Inside, a reception area with 4 plastic chairs and a counter staffed by a young man in a short-sleeved dress shirt. He's reading something on his phone. Doesn't look up when she enters. Help you? I'd like to file a judicial complaint. Now he looks up, studies her with the particular expression of someone who's heard this opening line hundreds of times. Fill this out. He slides a form across the counter without standing. Leave it in the box. Someone will review within 90 days. 90 days. That's the timeline. State requirement. He returns his attention to his phone. You can also file online if you prefer. Same timeline either way. She takes the form. 6 pages. Dense text. Boxes too small for detailed descriptions. A system designed to exhaust complainants before they finish complaining. The header reads, Marlow County Judicial Oversight Commission, Form JOC 7, Complaint Against Judicial Officer. Pursuant to Georgia Code Section 15-1-8, all complaints are reviewed by the court administrator within 90 calendar days. Complainants will receive written notification of disposition. Court Administrator. She checks the directory posted on the wall near the entrance. Felix Vance, Court Administrator. The same Felix Vance, whose signature appears on Judge Briggs's annual performance reviews, all rated satisfactory or exceeds expectations. The same Felix Vance who serves on the County Commission's Public Safety Committee alongside the same commissioners who oversee the courthouse budget. The same Felix Vance who, according to public records she'd reviewed during her preparation, plays golf every Thursday with County Attorney Malcolm Reed. She fills out the form anyway. Page 1. Complainant information. Name, address, phone number. She uses her home address, not the D.C. residence, not the court's address. Just a suburban house in a quiet neighborhood where the mail arrives every afternoon around 3. Page 2. Description of incident. The boxes allow approximately 150 words per section. She writes small, precise. Every moment documented. Page 3. Witnesses. She lists the people she can remember from the gallery. Mr. Patterson, elderly, cane, young woman with toddler, the teenagers in school uniforms. She doesn't know their names. Adds, additional witnesses available through courtroom access log for 11:14 a.m. proceedings. Page 4. Evidence. She notes the security cameras, the audio recording system, her own documents, copies attached. Pages 5 and 6. Acknowledgement of procedures, signature, date. She signs, dates, walks the completed form back to the counter. The young man takes it without looking up from his phone, drops it into a wire basket behind the counter, a basket already half full of other forms, other complaints, other citizens who believed the system would hear them. 90 days, he says again. We'll be in touch. I'd like a receipt. He sighs. The particular sigh of someone being asked to do something technically required but rarely requested. Fine. He stamps a copy of the first page, hands it to her. There, your receipt. Have a good day. She folds the receipt carefully, places it in her folder alongside the rest of her documents, walks out of the Office of Judicial Complaints without looking back. The first domino has fallen. Now she waits. Duck. 3 days pass. Vivian returns to Washington, to Chambers, to the work that defines most of her waking hours, cert petitions, brief reviews, the endless parsing of arguments that will shape American law for decades. She tells no one about the incident in Marlow County, doesn't mention it to her clerks, her colleagues, her security detail. The citation remains unpaid, officially listed as under appeal in the county's system, though no appeal has technically been filed yet. She has 30 days to decide whether to pursue formal legal challenge or simply pay and move on. She has no intention of doing either. On day 3, her personal phone rings, a number she doesn't recognize, Georgia area code. Justice Marlow? This is Marcus Webb. I used to clerk for you. 4th Circuit, 2019. The name triggers memory. Sharp young lawyer, ethical to a fault. She'd written him a recommendation letter when he applied to the DOJ Civil Rights Division 2 years ago. Marcus, it's been a while. How are you? I'm good, ma'am, but that's not why I'm calling. A pause. The sound of someone choosing words carefully. I need to ask you something. There's a video circulating. Courthouse security footage from Marlow County. A woman being removed from traffic court. The quality isn't great, but... He stops. Is that you? Someone had leaked the footage. Security camera from courtroom 3B. Grainy, no audio, timestamp visible in the corner. 3 minutes and 47 seconds of a woman at a podium. A judge waving dismissively. A security sergeant approaching. The walk out of the courtroom. Not much. Enough. The video had started on a local blog. Municipal court judge laughs at black woman, has her dragged out. Poorly edited. Minimal commentary. The footage speaking for itself. Within hours, it spread. Local news picked it up first. Atlanta stations hungry for content, recognizing the virality of institutional injustice caught on camera. Then national. Twitter threads dissecting every frame. Reddit users enhancing the footage, trying to identify the woman. TikTok reaction videos. The algorithm doing what algorithms do, amplifying outrage, multiplying attention, transforming 3 minutes and 47 seconds of surveillance footage into a referendum on municipal court justice. None of them knew who she was. Not yet. Vivian watches the footage on her laptop in her chambers at 9:47 p.m. on day 3. The quality is poor. The security camera positioned to capture the gallery, not the podium. She's visible mostly from behind. Gray cardigan, simple earrings. Her face briefly visible in profile when she turns toward the security sergeant. Not recognizable. Not to anyone who doesn't already know to look. But the footage includes Briggs. Includes his laugh. Includes the dismissive wave, the theatrical leaning back in his chair, the visible contempt for the woman standing at his podium. The comments beneath the video are a mixture of outrage and pattern recognition. This is every traffic court in America. Judge Briggs has a history. Ask anyone who's appeared in his courtroom. Does anyone know who this woman is? She deserves a lawyer. She didn't need a lawyer. She needed a judge who would actually listen. One comment catches her attention. Posted by an account with no profile picture, created the same day as the video's upload. I've filed complaints about this judge for 6 years. 43 cases of similar treatment. All dismissed. All buried. Maybe this time someone will finally pay attention. She screenshots the comment. Saves it. Doesn't respond. The system is beginning to move. Day 4. Her phone rings again. Another Georgia number. Miss Marlowe? My name is Rosa Delgado. I'm an attorney in Marlowe County, Public Defender's Office. Ms. Delgado. I saw your comment on the video. A pause. That was me, yes. The voice on the other end is tired. The kind of tired that comes from years of fighting battles no one acknowledges. I've been documenting Judge Briggs for 6 years, 43 cases where he treated minority litigants exactly like he treated you. I've filed complaints, formal grievances, ethics referrals. Nothing happens. Nothing ever happens. Until now. Maybe. Another pause. Miss Marlowe, I don't know who you are. I've tried looking you up, can't find much. Just a residential address, no professional history I can locate. But the way you handled yourself in that courtroom, the citations, the procedural knowledge, that wasn't someone's first time dealing with legal procedure. I've had some experience. I'd say so. A breath. I want to help. I've spent years building a case against Briggs that no one wanted to hear. Now people are paying attention. If you're willing to work together, combine your experience with my documentation, maybe we can finally make something stick. Vivian considers. The offer is genuine. The timing is right. But there are considerations Rosa Delgado can't know about, implications that extend far beyond a municipal traffic court. Ms. Delgado, I appreciate the offer, but I need to ask you something first. Anything. Your 43 cases. How many have supporting documentation? All of them. Every single one. Transcripts when available. Recordings when the court audio system was working. Complaint forms with timestamps. Witness statements. 6 years of evidence that Felix Vance keeps burying in his filing system. Good. Vivian writes Rosa's phone number on the notepad beside her keyboard. Keep everything. Organize it by date, by outcome, by demographic data. Make copies. Store them somewhere that isn't the courthouse. I already do. I learned that lesson the hard way. Then keep doing it. The right people are going to want to see it. The right people. Rosa's voice carries something that might be hope or might be skepticism. Hard to tell the difference after 6 years of disappointment. You sound like you know who those people are. I know that systems don't change because individuals deserve better. They change because someone documents the pattern until it can't be ignored anymore. You've been doing the documentation. Someone else will do the ignoring prevention. And that someone is you? In time, Ms. Delgado. In time. Day 5. The Georgia Judicial Conduct Commission issues a press release. Vivian reads it on her laptop, coffee growing cold beside her keyboard. The Judicial Conduct Commission has received multiple complaints regarding proceedings in Marlow County Municipal Court. Pursuant to Georgia Code Section 15-18, the Commission has assigned Inspector Nadine Cross to conduct a preliminary review of allegations concerning Judge Coleman Briggs. This review will examine procedural compliance, treatment of litigants, and adherence to established judicial standards. Judge Briggs remains on the bench during this review period. The Commission emphasizes that no findings have been made at this time, and all parties are presumed to have acted appropriately until evidence demonstrates otherwise. The Commission anticipates completing its preliminary review within 60 days. Citizens with relevant information may contact the Commission directly at the following address. Remains on the bench. Still hearing cases. Still dispensing 3-minute justice to people who look like the people he's been dismissing for 22 years. But an investigation has opened. An inspector has been assigned. The system is being forced to look at itself. That's something. Not enough, but something. The same afternoon, Felix Vance calls an emergency meeting. Vivian learns about it later, from sources she cultivates carefully. People inside the courthouse who've grown tired of looking away. The meeting happens behind closed doors. Vance's office. 3 attendees. Vance, Judge Briggs, and Assistant City Attorney Trent Lawson. The court stenographer who works the hallway outside catches fragments through the door. Damage control, media strategy, the importance of normal operations, and something else, finding out who leaked the video, finding out who this Vivian Marlowe really is. The complaint form lists her address, Vance says. I had someone check, vacant lot. She gave us a fake address. What about the car registration? Briggs asks. Still running it. DMV's backed up, but we'll find her. We'll find out who's behind this. They can't imagine the truth. Can't imagine that the woman in the gray cardigan doesn't need anyone behind her. That she is the someone others call when they need help. That the address she provided isn't fake. It's a property she owns under a trust, purchased years ago as an investment, technically occupied by a management company that handles mail forwarding. That the car registration leads to another trust, another layer of legitimate but obscured ownership. That everything about her presence in that courtroom was real, and everything about her identity remains, for now, invisible. Day 6. Vivian returns to Marlow County, not for her own case, for observation, for documentation, for the particular kind of preparation that comes from understanding exactly how a system operates before you attempt to change it. She wears the same gray cardigan, parks in the same lot. The parking attendant recognizes her, makes a call. By the time she reaches the courthouse entrance, Sergeant Pace is waiting. You again? His posture has changed since their last encounter. More alert, more aggressive. He's been briefed, told to watch for her, told to find out what she's doing here. Public building. She keeps her voice neutral. Public proceedings. I'm allowed to observe. Not if you're a security risk. On what basis am I a security risk, Sergeant? He doesn't answer, just stands in her path. Other people flow around them. Attorneys with briefcases, clerks with coffee cups, citizens with their citations and their hope. None of them stopped. Just her. You were removed from a courtroom 6 days ago. That makes you a person of interest. Person of interest. She lets the phrase hang. Interesting choice of words. Look, lady. He steps closer, close enough that she can smell his coffee breath, see the particular pattern of broken capillaries around his nose. I don't know who you are or what you're trying to prove, but Judge Briggs has been on that bench for 22 years. He's a respected member of this community. And you— He pauses, studies her face like he's looking for something. You're nobody. You're a traffic ticket that won't go away. And if you keep pushing, you're going to find out what happens to people who push around here. She holds his gaze. Sergeant, I'm going to step aside now and make a phone call. Then I'm going to enter this public building through that public entrance. If you prevent me, I'll need your supervisor's name for the federal civil rights complaint I'll be filing this afternoon. Federal? He laughs. Federal, sure. Go ahead and call whoever you want. Call the FBI. Call the White House. Call whoever makes you feel important. I'll be right here. She steps aside, pulls out her phone, doesn't make a call, just holds it, screen dark, giving him time to make a decision. He watches. 30 seconds, 45. A full minute of her standing motionless with a phone in her hand, showing no fear, showing no urgency, showing nothing but the particular kind of patience that comes from knowing exactly how this will end. He steps back. I'll be watching you. I'm counting on it, Sergeant. I'm counting on it. She walks past him, through security, into the courthouse. The body camera on his vest still isn't blinking. The sergeant thinks he's in control, but every threat he makes is another piece of evidence, and the pieces are adding up faster than he realizes. Inside, word has spread. The woman from the video is back. Vivian feels it immediately, the particular attention of people who've heard the rumors and want to see for themselves. Clerks glancing up from their desks, security officers tracking her movement through the lobby, the information network of a small courthouse, working exactly as intended. She takes a seat in the gallery of courtroom 3B, back row, same seat as before. Briggs is on the bench, same posture, same reading glasses, same 3-minute rhythm of justice dispensed to defendants who've learned not to fight back. He sees her enter. His gaze lingers for a moment. Recognition? Calculation? The particular wariness of a man who doesn't know exactly what threat she represents, but knows she represents something. Then he looks away. Calls the next case. Proceeds as if she isn't there. But she is there. Watching. Writing in her notepad. Documenting the same pattern she documented before. The disparate treatment, the rushed proceedings, the casual dismissal of anyone who tries to present evidence or question the system. After 40 minutes, someone slides into the seat beside her. Trent Lawson, the assistant city attorney who'd argued against her 6 days ago, still wearing the expensive watch, still wearing the confident expression. But something underneath it? Curiosity, maybe, or concern. Miss Marlowe, his voice is low, pitched for her alone. Interesting to see you here. Public building. Indeed. He straightens his tie. The gesture unnecessary, nervous. You know, I looked into your calibration argument after our last encounter. Clever approach. Most pro-C defendants don't think to challenge the equipment itself. Most pro-C defendants aren't given the chance to challenge anything. Fair point. He glances toward the bench where Briggs is in the middle of dismissing another defendant. But here's the thing. The legal argument you made, State v. Morrison, it doesn't actually support your position the way you claimed. The rebuttable presumption language requires expert testimony to overcome, not just printed documents. You cited the case, but you misread the holding. She turns to look at him. State v. Morrison, 2018, Georgia Court of Appeals, Justice Blackwell writing for the majority. Her voice doesn't change. Same tone, same pitch, same complete absence of doubt. The expert testimony requirement applies to scientific evidence challenged under Georgia Evidence Code 24-7702. Camera calibration records are business records under 24-8-8036. Self-authenticating government documents. different evidentiary standard. The county's own maintenance logs aren't scientific opinion. They're administrative fact. Lawson's confident expression flickers. I wasn't challenging the scientific calibration. I was challenging the county's compliance with its own maintenance requirements. No expert needed, just documentation that the county failed to follow the procedures it established, which I provided, which Judge Briggs refused to examine. You're not a lawyer. No, I'm not. Then how? Mr. Lawson. She closes her notepad. I've spent considerable time studying how legal systems work, for personal interest. What I've learned is that the law on the books is often quite different from the law in practice. Judge Briggs knows the law. He chose to ignore it. The question isn't whether I understood the evidentiary standards. The question is why a sitting judge chose to violate them. Lawson studies her, the calculation visible in his face, trying to figure out who she is, what she knows, how dangerous she might be to the system he's part of. You should be careful, Ms. Marlowe. You've made some powerful people uncomfortable. Uncomfortable. She stands, gathers her bag. That's the point, Mr. Lawson. That's always been the point. She walks out of the courtroom without looking back. Over the next 2 weeks, Vivian works quietly. Rosa Delgado's 43 cases become 51 as word spreads. Other public defenders come forward, private attorneys who've watched Briggs operate for years but never felt they had standing to complain. Court watchers and local journalists who'd noted patterns but couldn't prove them. Vivian connects them, not as their leader, that would require revealing too much, but as a coordinator, someone who asks the right questions, suggests the right organizational frameworks, helps isolated complaints become systematic documentation. Mr. Patterson, the elderly man with the cane from her first day in the courtroom, becomes one of her key contacts. He'd tried to challenge a calibration issue himself 4 years ago. Same judge, same dismissal, same buried complaint. I have copies of everything, he tells her during a phone call. Learned that the hard way. First time I filed, the original disappeared, so I started making copies, kept them at my sister's house in Atlanta. Good. The investigator will want to see them. The investigator. His voice carries something that might be hope or might be skepticism. You really think someone's finally going to listen? I think they won't have a choice, Mr. Patterson. When you document a pattern this thoroughly, eventually the pattern becomes undeniable. That's what they said about integration, too, back in 1964. Took another 20 years before anyone around here actually did anything about it. I know, but we're not waiting 20 years. Week 3. Inspector Nadine Cross arrives in Marlowe County. She comes with a federal subpoena and a reputation for thoroughness. Vivian learns about her through Rosa Delgado, a woman in her 40s with tired eyes and the particular manner of someone who spent years investigating institutional failures without becoming cynical about the possibility of reform. Cross's first meeting is with Rosa. The 43 cases, now 51, become the foundation of a pattern analysis. Disparate treatment, rushed proceedings, denied opportunities to present evidence. The same story told 51 different ways by 51 different citizens who'd never met each other. The 47 become 62 when Cross reviews court transcripts. Audio recordings from the courthouse system, supposed to be erased after 30 days, but a technical glitch preserved 6 months of proceedings. Briggs's voice captured in case after case, dismissing defendants, denying motions, laughing at people who tried to cite the law in a court of law. Cross doesn't reach out to Vivian directly. Not yet. The investigator is methodical, works from the outside in, interviews witnesses first, reviews documents second, approaches the central figures only when she understands the full picture. But Vivian knows she's coming. The invitation to testify, to become an official part of the record, is only a matter of time. Felix Vance is busy too. Vivian learns about this through the same sources who told her about the emergency meeting. The court stenographer, a clerk who's grown tired of looking away, an IT technician who noticed strange activity on the county's document management system. Complaint files, the ones that were supposed to be preserved for 90 days, are suddenly misfiled. Maintenance logs from the traffic camera system are unavailable due to system upgrade. Briggs's performance reviews, previously all satisfactory, are under revision for procedural compliance. Someone is covering tracks. Not well enough. The email chain that coordinates the cover-up will eventually surface, forwarded anonymously to Inspector Cross by someone inside the courthouse who's decided that conscience matters more than career. The subject line, document retention, urgent. The body, Felix. Per our conversation, the JOC-7 forms from the Briggs complaints should be moved to the off-site storage facility. Label as archived pending review. This removes them from the active file search, standard practice for sensitive matters. TL, Trent Lawson, the assistant city attorney with the expensive watch and the confident expression. The man who'd tried to explain the law to Vivian Marlowe in a courthouse gallery. The cover-up is becoming part of the case. Week 4. Inspector Cross requests a formal interview with Vivian. They meet at a neutral location, a conference room in the State Bar Building in downtown Atlanta. Neutral ground, official setting. The kind of place where testimony becomes record. Cross arrives precisely on time. Simple suit, minimal jewelry. The no-nonsense appearance of someone who's investigated enough cases to know that truth reveals itself through preparation, not presentation. Ms. Marlowe, thank you for making time. Of course. I've reviewed the footage from May 14th, the court audio, your complaint form, the pattern data Ms. Delgado has compiled. Cross opens a file folder, thin but organized. Before we begin, I need to ask you something. Go ahead. Your background. The inspector's eyes are sharp, assessing. The way you handled yourself in that courtroom, the citations, the procedural knowledge, the complete absence of hesitation. That's not typical pro se litigation. Most people who represent themselves in traffic court don't cite Georgia Evidence Code sections from memory. I've studied legal procedure extensively for personal interest. Personal interest. Cross lets the phrase hang. Ms. Marlowe, I've been doing this work for 15 years. I've interviewed hundreds of witnesses. I know when someone is holding something back. I'm not holding anything back, Inspector. I'm choosing what to disclose and when. That's an interesting distinction. It's an important one. Vivian meets the inspector's gaze. The question before the commission isn't who I am. It's whether Judge Briggs has engaged in a pattern of discriminatory treatment toward pro se minority litigants. My identity doesn't change the evidence. My identity doesn't change the 62 documented cases of disparate treatment. My identity doesn't change the audio recordings, the buried complaints, the coordinated cover-up you're going to discover when you subpoena the county's email servers. Cross's expression doesn't change, but something shifts behind her eyes. Recognition, maybe, or respect. Ms. Marlowe, the commission hearing is scheduled for 3 weeks from now. You'll be called to testify. Whatever you're choosing not to disclose, is it something that might affect your credibility as a witness? Inspector Cross. Vivian folds her hands on the conference table. I think you'll find my credibility is substantial, but I'd prefer to address that at the hearing, on the record, where everyone who needs to hear it can hear it at the same time. A long pause. Cross studies her with the particular intensity of someone trying to solve a puzzle with missing pieces. All right, Ms. Marlowe, on the record it is. She closes her file folder, stands. One more thing. Yes? The hearing will be recorded, transcribed. Everything said in that room becomes part of the permanent record. Whatever you're planning to reveal, be certain you're ready for the consequences. Vivian stands as well. I've spent my career thinking about consequences, Inspector. This time, I'm going to make sure the right people face them. The hearing is scheduled for June 11th. State Capitol Building. Judicial Conduct Commission Chamber. 3 weeks to prepare. 3 weeks of additional documentation. 3 weeks of Felix Vance scrambling to bury evidence and Trent Lawson drafting legal arguments, and Judge Briggs continuing to preside over courtroom 3B as if nothing has changed. But everything has changed. Vivian spends the intervening days organizing, coordinating, making sure every piece of evidence is documented, copied, secured. Rosa Delgado compiles her 62 cases into a comprehensive report: statistical analysis, outcome comparisons, timeline of buried complaints. Mr. Patterson and the other witnesses prepare their testimony: facts, not emotions; documentation, not accusations. The night before the hearing, Vivian receives an email. No sender address. No signature. Just a PDF attachment and 2 sentences. The attached was recovered from the county's backup server. Someone thought it was deleted. She opens the attachment. An internal memo. Subject line: Re. Prior complaints. Judicial coordination. Partially redacted. Sections blacked out. Names obscured. But one phrase visible near the bottom. Similar patterns documented in 3 adjacent counties. 3 adjacent counties. Similar patterns. Judge Briggs isn't alone. He's part of something larger, something the Commission's current investigation doesn't reach. She saves the document, forwards it to a secure address, files it away for later. One case at a time, one pattern at a time, one domino at a time. Tomorrow, the first domino falls in public. June 11th. June. 6:47 a.m. Vivian Marlowe stands in front of her closet for the first time since May, looking at her judicial robes. She doesn't touch them. Not yet. Today she wears the gray cardigan again, simple earrings, flat shoes. Today she's still just a citizen with a traffic ticket. Tomorrow, depending on what happens in the next 12 hours, she'll be something else entirely. The drive to Atlanta takes 90 minutes. Light traffic, NPR on the radio, the morning air already thick with Georgia humidity. The state capitol building rises at the end of the expressway, marble and brick, columns and domes, the architectural language of institutional authority. She parks in a visitor lot, walks through security without incident, takes the elevator to the 3rd floor. The Judicial Conduct Commission chamber is larger than she expected, not a courtroom, an administrative hearing room. Long table for the 5 commissioners. Witness stand to one side. Gallery seats filling rapidly with reporters, attorneys, and citizens who'd made the drive from Marlowe County. Rosa Delgado is already present. Seated in the front row of the gallery, file boxes at her feet. 62 cases reduced to organized documentation. She nods at Vivian. Vivian nods back. Mr. Patterson is present too, seated with his cane. Beside him, other witnesses, faces Vivian recognizes from phone calls and coordinated meetings. The young mother with the toddler, the middle-aged black man who'd tried to present calibration evidence, others whose stories had never been heard until now. At the respondents' table, Judge Coleman Briggs sits with his attorney, a former state Supreme Court justice now in private practice. Gray-haired, distinguished, the kind of lawyer you hire when you're guilty but need to look innocent. Briggs looks smaller than Vivian remembers. The bench in his courtroom elevated him, gave him height, gave him authority. Here, at a regular table in a regular room, he's just a man in his 60s with reading glasses and a nervous habit of adjusting his tie. He sees her enter, recognizes her. For a moment, their eyes meet. Something flickers in his expression. Uncertainty, maybe, or the beginning of fear. Then he looks away, confers with his attorney, pretends she doesn't exist. She takes a seat in the gallery, opens her notepad, waits. The commissioners enter at 9 a.m. precisely, 5 of them, 3 women, 2 men, senior judges, retired attorneys, legal scholars, the people responsible for holding the judiciary accountable. Commissioner Hayes, the chair, calls the hearing to order. This proceeding convenes to review allegations against Judge Coleman Briggs of the Marlowe County Municipal Court. Inspector Nadine Cross will present the Commission's preliminary findings. All parties have been notified of their right to counsel and their right to present evidence. Let's begin. Inspector Cross presents her case for 2 hours. The statistical analysis first. 62 cases reviewed. 47 involving minority pro-SE litigants. 41 of those resulting in maximum penalties without opportunity to present evidence. Average hearing time for minority defendants, 2.1 minutes. Average for white defendants, 4.7 minutes. Numbers don't lie. Numbers don't require interpretation. Numbers simply are. Then the audio recordings, case after case of Briggs's voice, dismissive, contemptuous, laughing at people who tried to cite the law. "Sir, this court doesn't have time for conspiracy theories about camera placement." "Ma'am, knowing big words doesn't make you a lawyer." "Guilty. $240. Pay at the window." "Next." The gallery listens in silence. Some of them, hearing their own cases played back. Their own moments of humiliation made official record. Then the document evidence. The buried complaints. The email chain showing coordination between Felix Vance and Trent Lawson. The pattern of obstruction that transformed isolated incidents into systematic cover-up. Cross reads the key email into the record. "Felix, per our conversation, the JOX 7 forms from the Briggs complaints should be moved to the off-site storage facility. Label as archived pending review. This removes them from the active file search. Standard practice for sensitive matters. TL." The room stirs. Reporters take notes. Briggs's attorney objects. Hearsay, chain of custody, selective presentation. Some objections sustained, most overruled. The evidence accumulates anyway. Witnesses testify through the afternoon. Mr. Patterson takes the stand first. His voice shakes, but his documents don't. "I tried to present evidence in 2020. Calibration records, same as the woman in the video. Judge Briggs told me I was wasting his time. Told me to pay my fine and be grateful he wasn't adding contempt charges. I'm 73 years old. I served my country. I never got to say my piece." Rosa Delgado testifies next. 20 years of advocacy condensed into 45 minutes. "I've represented clients in Judge Briggs's courtroom who were found guilty before they finished stating their names. I've filed 19 formal complaints over 6 years. Not one resulted in action. The system protected him because the system benefited from his efficiency. Volume over justice. That was the model. That was always the model." The young mother, whose name turns out to be Keisha Washington, testifies about her experience. A red light violation that cost her $300 she couldn't afford. The judge who laughed when she tried to explain she was rushing to get her sick child to the hospital. He said, "Everyone has a sob story." That's what he said. Everyone has a sob story. Then he doubled my fine for wasting court time. Briggs's attorney cross-examines each witness, tries to create reasonable doubt, suggests selective memory, personal grudges, coincidental patterns that don't prove intentional discrimination. Some points land, most don't. The audio recordings don't lie. The statistical analysis doesn't lie. The pattern documented across 62 cases doesn't lie. By 4:30 p.m., the commission takes a 15-minute recess. Vivian remains in her seat, checks her phone. No messages, no interruptions. The dominoes are falling exactly as planned. 4:45 p.m. The commission reconvenes. Commissioner Hayes checks his schedule. We have one final witness, the complainant in the May 14th incident, Ms. Vivian Marlowe. She rises from the gallery. The room shifts. People who'd been watching all day suddenly paying sharper attention. Reporters who'd been waiting for this moment lifting their phones. Briggs's attorney straightening in his chair. She walks to the witness stand, places her hand on the Bible, takes the oath. "Do you swear to tell the truth, the whole truth, and nothing but the truth?" "I do." She sits. She folds her hands on the rail in front of her, looks directly at the commissioners. Commissioner Hayes clears his throat. "Miss Marlowe, please state your full name and occupation for the record." The room holds its breath. She's waited 6 weeks for this moment. 6 weeks of documentation. 6 weeks of coordination. 6 weeks of watching a system try to protect itself while she assembled the evidence that would force it to change. Now the moment arrives. "My name is Vivian Elise Marlowe." She pauses. Every eye on her. Briggs looking up from the respondent's table. recognition flickering across his face. Not full understanding yet, but something. The sense that what comes next will change everything. I am an Associate Justice of the Supreme Court of the United States. Silence. Complete. The kind of silence that has weight and mass and density. Then chaos. Reporters standing. Camera phones rising. Briggs's attorney frozen mid-reach for his water glass. Commissioner Hayes's gavel cracking once, twice, 3 times against the bench. Order! Order! Briggs himself, pale now, gripping the edge of the table, staring at the woman he'd laughed at, the woman he'd had removed from his courtroom, the woman who outranks every judge in the country, the woman whose career he tried to humiliate, the woman who just destroyed his. Justice Marlowe, Commissioner Hayes's voice falters. The commission was not aware. I requested that my credentials not be disclosed until this moment. Her voice carries clearly over the subsiding chaos. I wanted the commission to evaluate the evidence on its merits, not because of who the complainant happened to be. She looks directly at Briggs. The pattern documented by Inspector Cross would be equally egregious if the victim were a retired schoolteacher or a single mother working 2 jobs. My position shouldn't make this more serious. It's already serious. It was always serious. The only difference is that now, people are listening. Briggs's attorney is on his feet. Your Honor, Commissioners, this is highly irregular. The Commission cannot proceed with testimony from a witness who deliberately concealed material information about her identity. Counselor, Commissioner Hayes's voice cuts through. Sit down. The attorney sits. Justice Marlowe, you may continue. She does, for 45 minutes, calm, precise, devastating. On May 14th, I appeared in traffic court like any other citizen. I came with evidence. I came with specific legal citations. I was denied the opportunity to present that evidence. I was denied my right to note my objection. I was physically removed from a public courtroom while attempting to exercise constitutional rights that apply to every American, regardless of race, regardless of income, regardless of whether they hold a law degree or a Supreme Court appointment. The only explanation for that treatment is that Judge Briggs saw a black woman without an attorney and decided, before I spoke a word, that I had nothing worth hearing. She pauses. Under 28 U.S.C. Section 455, federal judges must recuse themselves when their impartiality might reasonably be questioned. The same principle underlies Georgia Code Section 15-18, which governs judicial conduct in this state. Judge Briggs didn't recuse himself from judging me. He recused himself from hearing me. He decided, based on what he saw, that I was not entitled to the same process as other litigants. That's not efficiency. That's not judicial discretion. That's discrimination. And it happened because he thought no one with power was watching. She looks directly at Briggs, holds his gaze. I'm just the one with enough privilege to make the system finally listen. But the 62 people whose cases you've heard today, they didn't have that privilege. They were dismissed and humiliated and told their evidence didn't matter. They filed complaints that were buried. They tried to exercise their rights and were laughed out of court. They deserved better. They deserved the same process I deserved. They deserved a judge who would hear them. She turns back to the commissioners. I'm not here for revenge. I'm here for the record, for the 62 citizens who never got their day in court, for the hundreds more we haven't documented yet, for the pattern that will continue unless this commission acts. She folds her hands. I'm done. The commission adjourns for deliberation at 6:17 p.m. The gallery doesn't clear. No one leaves. Reporters file breaking news stories from their phones. Rosa Delgado sits with her file boxes, tears streaming silently down her face. Mr. Patterson holds his cane with both hands, staring at the empty witness stand. Vivian sits in the gallery, waiting. At 8:43 p.m., the commissioners return. Commissioner Hayes reads the findings. On the charge of conduct prejudicial to the administration of justice, sustained. On the charge of failure to perform judicial duties impartially, sustained. on the charge of violation of litigants' due process rights, sustained, each word landing like a gavel. Judge Coleman Briggs is hereby suspended from the bench, effective immediately, pending completion of the full investigation. During this suspension, Judge Briggs shall receive half pay. The Commission anticipates issuing final findings within 90 days. Not removed, not yet. Half pay, appeals pending. The system moving, but slowly, partially, the way systems always move. Commissioner Hayes continues. Additionally, the Commission refers the matter of Court Administrator Felix Vance to the State Bar for ethics review and to the District Attorney's Office for potential criminal investigation regarding obstruction of judicial proceedings. The Commission also refers Assistant City Attorney Trent Lawson to the State Bar for review of his role in document suppression. Referrals, reviews, potential investigations. Not convictions, not yet, but the dominoes are falling, one at a time, exactly as planned. Outside the state capitol, the night air is warm, the parking lot half empty now, most of the reporters gone to file their stories. Vivian stands on the marble steps, looking out at the city lights. Rosa Delgado approaches. Justice Marlowe? She says the title like she's still getting used to it. I don't know what to say. 6 years I've been fighting this. 6 years of nothing. And you, in 6 weeks? I didn't do anything you weren't already doing, Ms. Delgado. You documented the pattern. You preserved the evidence. You never stopped fighting even when no one would listen. But they listened to you. They listened to the evidence. I just made sure they couldn't ignore it. Rosa shakes her head. You could have sent a letter, made a phone call. Your position. You could have ended this without ever setting foot in that courtroom. I could have. Vivian looks out at the city, the dome of the Capitol lit against the dark sky. But that wasn't the point. Then what was? The point was to understand what it feels like. To stand in a courtroom without credentials, without authority, without anyone who knows who you are, and try to exercise rights the Constitution guarantees. The point was to experience what 62 people before me experienced, what thousands of people across this country experience every day. She turns to face Rosa. I make decisions that affect millions of lives. I rule on cases that determine what rights mean in practice, not just in theory. But I've spent most of my career in spaces where people know who I am, where doors open before I reach them, where no one laughs when I cite a statute. She pauses. I needed to know what it feels like when the doors stay closed, when the laughing doesn't stop, when the system looks at you and decides, before you speak, that you don't matter. Rosa is quiet for a moment. And now you know. Now I know. This case changed how a Supreme Court justice sees the justice system. But the biggest revelations are still coming. Part 2 drops everything. The drive back to Washington takes 8 hours. Vivian doesn't take a flight, doesn't call her security detail, just drives through the Georgia night, then the Carolina dawn, then the Virginia morning, watching America scroll past her windows, thinking about the cases she'll review when she returns, the rights she'll interpret, the precedents she'll set, thinking about 62 citizens who never got to present their evidence, thinking about a judge who laughed, thinking about a system that only listened because someone with power finally made it listen. The radio plays NPR. The news cycle has already moved on. Trade negotiations, congressional hearings, the endless churn of democracy in action. The Marlowe County case will fade from headlines within a week. Briggs will appeal. Vance will hire lawyers. The pattern documented across 62 cases will become a footnote in administrative law textbooks. But the precedent will remain. And somewhere in Georgia, a young woman will walk into traffic court with a folder full of documents. A judge will look at her and decide, consciously or not, whether to hear her or dismiss her. And maybe this time that judge will remember. Remember that the woman in the gray cardigan turned out to be a Supreme Court justice. Remember that systems can be held accountable. Remember that people are watching. always watching. 3 weeks after the hearing, Vivian receives a letter. No return address. Postmarked Marlowe County. Handwritten. She opens it at her desk in chambers, the late afternoon light falling across the page. Justice Marlowe, I was in the courtroom that day, watching. I didn't say anything. Didn't stop them. I've been thinking about that every day since. About the officers who stayed silent while you were arrested. About clerks who moved cases to hurt people. About all of us who saw wrong and did nothing. I'm trying to do better now. I hope that matters. Anonymous. She reads it twice, folds it carefully, places it in the folder where she keeps the documents from the Marlowe County case, the complaints, the receipts, the evidence of a system that tried to protect itself and failed. One person trying to do better. It's not systemic change. It's not justice. But it's something. Shay. And then her phone buzzes. A text from Marcus Webb, her former clerk, now at DOJ. Justice Marlowe, we need to talk. The email you forwarded, the one about similar patterns in 3 adjacent counties, we've been investigating. What we found is bigger than we thought. Much bigger. She reads the message. Reads it again. The memo. The redacted names. The phrase that had caught her attention. Similar patterns documented in 3 adjacent counties. She'd thought Briggs was the problem. She was wrong. Briggs was just the door. The text glows on her phone screen. 3 sentences that change everything. Justice Marlowe, we need to talk. The email you forwarded, the one about similar patterns in 3 adjacent counties? We've been investigating. What we found is bigger than we thought. Much bigger. Vivian sets down the anonymous letter. Picks up the phone, calls Marcus Webb. He answers on the first ring. Justice Marlowe, thank you for calling back. Tell me what you found. A pause. The particular silence of someone organizing information that doesn't organize easily. The memo you forwarded referenced similar patterns in 3 adjacent counties. We assumed that meant 3 other judges with the same problems as Briggs. Isolated bad actors. Individual misconduct that happened to cluster geographically. But that's not what you found. No, ma'am. Another pause. What we found is a network. Coordinated, deliberate. Stretching across 4 counties, involving at least 7 judges, 12 court administrators, and, this is the part that concerns us most, connections to the State Attorney General's office. The air in her chambers seems to thicken. Explain. The pattern in Marlowe County, the buried complaints, the disparate treatment, the revenue-focused justice model, it's not unique. It's a template. Someone designed it. Someone implemented it across multiple jurisdictions. And someone has been protecting it from oversight for at least a decade. Vivian walks to her window. The Capitol dome visible in the distance, lit against the evening sky. Who? We don't know yet. The money trail leads to a consulting firm called Judicial Efficiency Partners. They provide court optimization services to municipal courts across Georgia. Their client list includes all 4 counties we're investigating. Court optimization? That's what they call it. What it actually means is maximizing citation revenue while minimizing procedural overhead. Fewer hearings, faster convictions, higher collection rates. The judges who cooperate get favorable performance reviews, the ones who don't get transferred or pressured out. And the State Attorney General's office? JAP's largest investor is a real estate development company called Piedmont Holdings. Piedmont's CEO is Harrison Vance, Felix Vance's brother. Yes, ma'am. And Harrison Vance was the finance chair for the current Attorney General's campaign. $3.2 million in bundled contributions over 2 election cycles. Vivian closes her eyes, the scope of it settling into place. Not one corrupt judge, not one buried complaint system. A network, a business model, a machine designed to extract money from citizens too poor to hire lawyers, protected by political connections too powerful to challenge. What do you need from me? The commission hearing cracked the door open. Briggs is suspended. Vance and Lawson are under investigation. But the DOJ can't open a pattern or practice investigation without clear evidence of systemic civil rights violations across multiple jurisdictions. Right now, we have suspicion. What we need is documentation. Rosa Delgado has 62 cases from Marlow County alone. We need more. Cases from the other 3 counties. Witnesses willing to testify. Financial records showing how the revenue system actually works. Marcus's voice carries the particular weight of someone asking for something difficult. And we need someone with standing to push for federal intervention. Someone whose voice carries weight with the agencies that would need to authorize this kind of investigation. You're asking me to involve the court. I'm asking you to consider it. The 14th Amendment implications alone, if municipal courts across Georgia are systematically denying due process to minority citizens as part of a coordinated revenue scheme, that's not just misconduct, that's a constitutional crisis. Vivian watches the Capitol Dome, the seat of legislative power, the place where laws are written that her court interprets. Send me everything you have, encrypted. I'll review it tonight. Yes, ma'am. And Marcus? Yes? The state attorney general. If his office is connected to this, he'll try to shut the investigation down. He has the power to interfere with state-level proceedings, pressure witnesses, redirect resources. We've considered that, which is why we're building the federal case first. Once we have enough evidence for DOJ Civil Rights Division to open formally, state interference becomes obstruction of a federal investigation. Different game entirely. Good. Keep me informed. She ends the call. Stands at the window for a long moment, watching the lights of Washington, thinking about the lights of Marlow County. The courthouse where she'd been laughed at. The courtroom where 62 citizens had been denied their moment to be heard. She'd thought she was fighting one battle. She was wrong. The battle was just beginning. The corruption goes deeper than anyone imagined, and Justice Marlow is about to discover just how far the system will go to protect itself. 2 weeks after the commission hearing, the consequences begin to cascade. Not all at once, not dramatically. The way institutional accountability actually works, slowly, procedurally, with plenty of room for the guilty to maneuver and the innocent to be forgotten. Sergeant Wendell Pace is the first to fall. Not for the incident with Vivian specifically, that would require criminal charges, which the district attorney's office is still evaluating. Instead, Pace is terminated for pattern of excessive force documented across multiple complaints. The complaints had existed for years, buried in the same filing system that buried everything else. But now, with Inspector Cross's investigation still active and reporters digging through public records, the complaints have resurfaced. 16 incidents over 8 years. 16 citizens who'd filed grievances that went nowhere. 16 data points in a pattern that suddenly can't be ignored. The termination notice is procedural. 3 paragraphs. Effective immediately. Pace's union files an appeal. The appeal will take 18 months to resolve. In the meantime, he's out. No badge, no gun, no authority to remove anyone from anywhere. Vivian learns about it through Rosa Delgado, who's become her primary contact for developments in Marlow County. He's already hired a lawyer, Rosa reports during a phone call. Claims the termination is retaliation for his role in the Briggs case. Says he was just following orders. Following orders from whom? That's the question, isn't it? Pace is claiming Briggs personally instructed him to remove difficult litigants. If that's true, it adds another layer to the misconduct charges. If Pace is lying to save himself, it muddies the investigation. What about the body camera footage from my incident? That's the interesting part. Pace's camera was supposed to be recording. Department policy requires activation during any citizen contact. But the footage from that morning shows a gap. Camera activated at 9:32 a.m., deactivated at 9:41 a.m., reactivated at 10:15 a.m. Your removal happened at 9:47. Convenient timing. Very convenient. It is claiming the gap was a technical malfunction. Inspector Cross is claiming it was deliberate evidence destruction. The truth is probably somewhere in between. Pace knew enough to turn his camera off, but not enough to cover his tracks properly. What about other officers' footage? Officer Randall, the one at the security checkpoint, had his camera running the whole time. It captured your entry into the building, your conversation with him, your walk to the second floor. No audio until you entered the courtroom, but visual confirmation of everything you've described. And the courtroom recordings? That's where it gets complicated. Rosa's voice carries something new. Not quite hope, not quite frustration. The court audio system recorded everything. Briggs's dismissal, your objections, the order to remove you. Perfect documentation of exactly what happened. But Felix Vance is claiming the recordings are inadmissible because they were retained past the 30-day deletion window without proper authorization. He's trying to suppress evidence by arguing his own department violated policy. Exactly. The irony would be funny if it weren't so infuriating. Vance buried complaints for years by claiming they were misfiled. Now he's trying to protect Briggs by claiming the evidence against him was improperly preserved. Will it work? Inspector Cross doesn't think so. The recordings exist. They've been authenticated. The chain of custody is documented. Vance's procedural argument is a delay tactic, not a defense, but it will add months to the timeline. Months. Vivian thinks about the 62 citizens whose cases have already waited years, about the hundreds more across 4 counties whose stories haven't been told yet. What about the other counties? The ones Marcus Webb mentioned? DOJ is being careful. They're building the federal case slowly, interviewing witnesses, subpoenaing financial records, mapping the connections between judicial efficiency partners and the court systems they optimized. But they won't move publicly until they're ready. Too many powerful people involved. Too much risk of the investigation being shut down prematurely. And in the meantime? In the meantime, Briggs sits at home collecting half salary. Vance lawyers up. Lawson negotiates with the state bar. The system protects itself the way it always protects itself, with procedure and delay and the assumption that eventually everyone will lose interest and move on. Not this time. No. Rosa's voice carries something that sounds almost like a smile. Not this time. Margot Stiles resigns 3 weeks after the hearing. No formal charges, no admission of wrongdoing. Just a quiet departure and a county severance package that includes confidentiality provisions preventing her from discussing any matters related to her employment with Marlow County Municipal Court. The resignation letter is 2 sentences. I am resigning my position effective immediately for personal reasons. I wish the county well in its future endeavors. Vivian learns about it through the same courthouse sources who've been feeding information to Rosa Delgado. A network of people who'd watched the system protect itself for years and finally decided to help document its failures. The clerk who replaced Stiles is younger, newer, still idealistic enough to believe that processing cases fairly is part of the job description. Whether that idealism survives contact with institutional pressure remains to be seen. Small victories. Incremental changes. The way reform actually happens, not in dramatic revelations that fix everything overnight, but in the slow accumulation of consequences that make misconduct slightly harder, slightly riskier, slightly more visible than before. Trent Lawson's State Bar review begins 6 weeks after the hearing. The process is confidential. Proceedings closed, evidence sealed, outcome pending. But rumors circulate through the legal community. Lawson has hired a prominent ethics attorney. He's cooperating with investigators. He's prepared to testify about the instructions he received from Felix Vance, the document suppression he participated in, the system he helped maintain. Cooperation in exchange for leniency. The same calculation made by mid-level participants in every institutional scandal. Someone has to take the fall. Someone else gets to negotiate their way out. Vivian follows the developments from Washington, where her regular work continues: cert petitions, oral arguments, the endless parsing of constitutional questions that will shape American law for generations. The Marlowe County case occupies a particular corner of her attention, but it's not the only case. Can't be the only case. The court's work doesn't stop because one justice experienced what millions of citizens experience every day. But she doesn't forget. Every traffic court case that crosses her desk now carries additional weight. Every 14th Amendment challenge, every due process question, every claim of institutional discrimination. She reads them differently now. Reads them as someone who stood in a courtroom without credentials, without authority, without anyone who knew her name, and tried to exercise rights the Constitution guarantees. She reads them as someone who knows what it feels like when the system decides you don't matter. 8 weeks after the hearing, Marcus Webb requests another meeting. This time, he comes to Washington. They meet in Vivian's chambers, secure, private, away from the surveillance that inevitably surrounds federal investigations of this scope. He brings files. Brings thick folders organized with the particular precision of someone building a case that needs to survive appeals. We've identified the network, he says, spreading documents across her conference table. 7 judges across 4 counties, all connected to judicial efficiency partners, all showing the same pattern: disparate treatment of minority pro-se litigants, buried complaints, revenue-focused case processing. Vivian studies the documents. Names she doesn't recognize, courthouses she's never visited, patterns that mirror exactly what she experienced in Marlowe County. The financial structure is sophisticated, Marcus continues. JEP doesn't pay the judges directly. That would be too obvious. Instead, they provide consulting services to the county court systems, training programs, efficiency audits, technology upgrades. The counties pay JEP. JEP invests in Piedmont Holdings. Piedmont develops properties in the counties where JEP operates. Everyone profits except the citizens being processed through the system. And the state attorney general? Harrison Vance, Felix's brother, bundled campaign contributions for A.G. Morrison's last 2 elections. $3.2 million total. Morrison's office has declined to investigate any complaint against judges in JEP-affiliated courts for the past 6 years. Every referral from the Judicial Conduct Commission, every citizen complaint, every ethics concern, all declined for insufficient evidence. Obstruction. At minimum. We're also looking at potential conspiracy charges, depending on how directly Morrison was involved in the suppression. Vivian leans back in her chair, the scope of it settling into place. Not a few bad actors, a system, a machine, designed, implemented, protected. What do you need to move forward? The evidence we have is strong but circumstantial. We can prove the financial connections. We can prove the pattern of declined investigations. What we can't prove, yet, is that Morrison knew the courts were violating civil rights and deliberately chose not to act. You need someone inside. We need testimony, someone who was part of the system and is willing to explain how it actually worked. Right now, everyone's lawyered up. No one's talking. What about Lawson? He's cooperating with the State Bar Review. Limited cooperation. He'll testify about document suppression in Marlowe County. He won't testify about the larger network because he claims he didn't know about it. Whether that's true or whether he's protecting himself by limiting his exposure, we can't tell yet. Vivian thinks about the courthouse employees who'd fed information to Rosa Delgado, the anonymous sources who'd forwarded emails, the people inside the system who'd finally decided that conscience mattered more than career. There are people in Marlowe County who've been helping document the pattern. Clerks, technicians, lower-level staff. They've been feeding information anonymously because they're afraid of retaliation. We've interviewed some of them. Good information about local operations, but they don't have visibility into the larger network. They knew their own courthouse was problematic. They didn't know it was part of a coordinated system. Then you need someone higher up. Yes. Marcus meets her gaze. Which is why I'm here. Felix Vance is facing ethics charges and potential criminal prosecution. His brother's company is the financial hub of the entire network. If Felix decides to cooperate, really cooperate, he could give us everything. You want me to help convince him? I want you to consider reaching out. Not officially, that would create all kinds of procedural complications. But you experienced his system firsthand. You testified about it publicly. If anyone has standing to explain to Felix Vance what's coming and what his options are, it's you. Vivian stands, walks to her window, the Capitol dome glowing in the afternoon light. Felix Vance tried to bury my complaint. He coordinated the suppression of evidence. He's been protecting corrupt judges for years. Yes. And you want me to offer him a path to redemption. I want you to offer him a choice. Cooperate now while he still has something to trade. Or wait until we build the case without him and watch his brother's empire collapse while he goes down as a co-conspirator rather than a cooperating witness. You're asking me to be the stick disguised as a carrot. I'm asking you to be the person who tells him the truth, which is more than the system ever offered the 62 citizens whose cases he buried. The meeting with Felix Vance happens 10 days later. Neutral location. A law office in Atlanta, selected for its discretion and its distance from Marlow County. Vance arrives with his attorney, a criminal defense specialist who's handled white-collar cases for 2 decades. Vivian arrives alone. The conference room is anonymous. Beige walls, mahogany table. The particular emptiness of spaces designed for difficult conversations. Vance looks older than his photographs. The stress of the past 2 months visible in the lines around his eyes, the gray at his temples, the particular tension in his shoulders that comes from waiting for consequences that haven't fully arrived yet. His attorney speaks first. Justice Marlowe, my client appreciates your willingness to meet. However, I should note that any statements made in this conversation are inadmissible and protected by... I'm not here to gather evidence, counselor. Vivian's voice is calm, measured, the same tone she'd used in the courtroom where Vance's system had tried to silence her. I'm here to have a conversation. What Mr. Vance does with that conversation is entirely up to him. Vance's attorney glances at his client. Vance nods slightly. The attorney settles back in his chair but doesn't leave. Mr. Vance? Vivian folds her hands on the table. You know who I am. You know what I experienced in your courthouse. You know what the investigation has uncovered so far. What you may not know is what's coming next. I'm aware of the allegations, Vance says carefully. My attorney has advised me not to discuss specifics. Then let me discuss them for you. The Department of Justice is building a pattern or practice case against 4 county court systems in Georgia. Judicial Efficiency Partners, the company your brother founded, is at the center of that investigation. The financial connections between JEP, Piedmont Holdings, and the campaign contributions to Attorney General Morrison are documented. The only question is, how many people go down when the indictments come? Vance's face remains carefully neutral, but something flickers behind his eyes. Fear, maybe, or calculation. Right now, you're positioned as a co-conspirator, a knowing participant in a scheme to violate citizens' civil rights for financial gain. That's federal charges, Mr. Vance, not state ethics review, not administrative suspension, federal prosecution, federal sentencing guidelines, federal prison. My client has not been charged with any federal crimes, his attorney interjects. Not yet. The investigation is ongoing, but when it concludes, and it will conclude, the DOJ will need to decide who was an architect of this system and who was a participant following instructions. The architects face the harshest consequences, the participants who cooperate. Sometimes they face less. Silence in the conference room. Vance's attorney studying Vivian's face, trying to read the strategy behind the words. What exactly are you proposing? The attorney asks. I'm not proposing anything. I'm explaining reality. Mr. Vance has information about how this system operated, who designed it, who benefited, who knew what and when. That information has value, but only if it's offered before the DOJ completes their investigation without it. Vivian stands. I'm not here to negotiate a deal. That's for the prosecutors. I'm here because 62 people in your county were denied justice by a system you helped maintain, because hundreds more across 4 counties experienced the same thing, because the Constitution I've sworn to uphold guarantees equal protection and due process, guarantees your system systematically violated. She walks toward the door, pauses. I'm also here because I believe in redemption, Mr. Vance. I believe people can choose to do the right thing even after they've spent years doing the wrong thing. But that choice has a window, and the window is closing. She leaves. The conversation she doesn't hear happens after she's gone. Vance and his attorney, weighing options, calculating risks, considering cooperation. She doesn't know what they'll decide. But she's planted the seed. The walls are closing in, and Felix Vance isn't the only one who has to make a choice. 3 weeks after the meeting, Felix Vance begins cooperating with the DOJ. Vivian learns about it through Marcus Webb, who calls her with barely contained excitement. He's talking, everything, the financial structure, the political connections, how GEP recruited judges and court administrators, how complaints were systematically buried, how Morrison's office was kept informed about which investigations to decline. All of it. What changed his mind? His attorney ran the numbers. If Vance goes to trial as a co-conspirator, he's looking at 15 to 20 years federal time. If he cooperates fully and testifies against the architects, including his brother, he might get 5 years, possibly less with good behavior. Blood is thinner than prison time. Apparently so. Harrison Vance is furious. He's trying to claim Felix is lying, that he's been manipulated by the DOJ, that this is all politically motivated prosecution. But the documents Felix is providing are too detailed to dismiss. Internal memos, financial transfers, communication logs. The kind of evidence that doesn't exist if there's no conspiracy to document. What about Morrison? That's where it gets complicated. Felix can testify about what Morrison's office did, the declined investigations, the buried referrals, but he can't testify about Morrison's personal knowledge because he never dealt with Morrison directly. Everything went through intermediaries. The Attorney General maintained plausible deniability. Smart. Smart enough to survive, maybe, but the intermediaries are now facing their own exposure. Some of them might decide that cooperation is better than loyalty. We're making offers, building pressure, trying to work our way up the chain. How long until you can move publicly? 6 months minimum, probably longer. Federal civil rights investigations take time, especially when they involve public officials. We need bulletproof evidence because we'll be fighting well-funded defense attorneys and political pressure at every stage. And in the meantime, the judges in the network are getting nervous. 2 of the 7 have already announced early retirement, for health reasons and to spend more time with family. Translation: they see the writing on the wall and they're trying to exit before the indictments come. Does retirement protect them? From criminal prosecution? No. From civil liability? Partially. From professional consequences? Mostly. If they retire before formal charges, they keep their pensions. The system is designed to let them exit gracefully, even when they don't deserve grace. Vivian thinks about Judge Briggs, still suspended, still collecting half salary, still waiting for the Commission's final determination while appeals and motions work their way through the system. What about Briggs? The Commission's final report is due in 3 weeks. Our sources say they're recommending permanent removal from the bench, but Briggs's attorney has already signaled he'll appeal. The appeals process could take years. Years. That's how the system works. You know that better than anyone. Justice moves slowly. Accountability moves slower. The people with power have resources to delay consequences indefinitely. Not indefinitely. Vivian's voice carries something that might be determination or might be acceptance. Eventually, the delays run out. Eventually, the consequences arrive. For some people, not for everyone. No, not for everyone, but for enough people that the system learns it can't protect itself forever. The Judicial Conduct Commission issues its final report on Judge Coleman Briggs 12 weeks after the initial hearing. The document is 47 pages. dense with findings, citations, documentary evidence. The summary is 3 paragraphs that will define the end of a career. The Commission finds that Judge Coleman Briggs engaged in a pattern of conduct prejudicial to the administration of justice over a period of at least 6 years. This conduct included, but was not limited to, systematic denial of due process to pro se litigants, disparate treatment based on race and socioeconomic status, improper removal of citizens exercising constitutional rights, and coordination with court administrative staff to suppress complaints and obstruct oversight. The Commission further finds that Judge Briggs's conduct was not isolated error, but reflected deliberate policy, a prioritization of case volume and revenue generation over the fundamental requirements of fair adjudication. The evidence demonstrates that Judge Briggs was aware his practices violated established standards and chose to continue them regardless. Based on these findings, the Commission recommends that Judge Coleman Briggs be permanently removed from the bench, effective immediately, and that his judicial pension be subject to forfeiture proceedings consistent with Georgia Code Section 47-23-104. Permanent removal. Pension forfeiture. Not criminal charges. Not yet. The District Attorney's Office is still evaluating whether to pursue prosecution under state civil rights statutes. The evaluation will take months. The outcome is uncertain, but the career is over, the authority is gone. The man who laughed at citizens for 22 years will never sit on a bench again. Briggs's attorney announces an appeal within hours of the Commission's report. The appeal argues procedural errors, due process violations, selective prosecution. The same arguments that have delayed accountability in 1,000 similar cases. The appeal will take years to resolve. Vivian reads the Commission's report in her chambers, the afternoon light falling across the pages. She reads every finding, every citation, every piece of evidence that documents what she experienced and what 62 citizens before her experienced. She reads the section about herself carefully. The incident of May 14, 2024, involving Justice Vivian Marlowe of the United States Supreme Court, represents a particularly egregious example of the pattern documented throughout this report. Justice Marlowe appeared in traffic court as an ordinary citizen, presented legitimate evidence challenging her citation, and was denied the opportunity to be heard, denied the right to note her objection, and physically removed from the courtroom by security personnel. The Commission notes that Justice Marlowe's experience differs from most documented incidents only in its outcome. Her position provided her the resources and platform to pursue accountability that most citizens lack. The treatment she received was consistent with the treatment documented in 62 other cases. The only difference is that this time the system was forced to respond. She sets down the report, looks out her window at the Capitol dome. The system was forced to respond. Not because it wanted to, not because justice demanded it, because someone with power experienced what powerless people experience every day, and the system couldn't ignore that the way it ignores everyone else. That's not justice. That's the failure of justice, briefly interrupted. But it's something, and something is better than nothing. The Marlowe County Board of Commissioners meets 2 weeks after the Commission's report. The meeting is technically about the county budget, routine appropriations, departmental allocations, the mundane business of local government. But everyone knows what's really on the agenda. Vivian doesn't attend. She's back in Washington doing the work the Constitution requires. But Rosa Delgado is there, sitting in the front row of the public gallery with her file boxes beside her. Other advocates are present too. Community organizers, civil rights attorneys, citizens who've been fighting the system for years and finally feel like someone's listening. The commission chair, a portly man named Delbert Harrison, who's served on the board for 16 years, calls the meeting to order at 7 p.m. Before we proceed with the regular agenda, the board will hear a presentation from the county attorney regarding recent developments in the municipal court system. The county attorney, not Malcolm Reed, who resigned 3 weeks ago amid his own ethics investigation, but his replacement, a woman named Patricia Okonkwo, who was hired specifically because she had no connections to the previous administration, approaches the podium. Chairman Harrison, members of the board, in light of the Judicial Conduct Commission's findings regarding former Judge Briggs and the ongoing investigations by state and federal authorities, the county attorney's office has prepared recommendations for structural reforms to the municipal court system. She distributes a packet to each commissioner. 12 pages of proposed changes. First, we recommend mandatory audio and video recording of all municipal court proceedings, with recordings retained for a minimum of 2 years. This exceeds state requirements, but provides necessary documentation for oversight and accountability. Second, we recommend establishment of an independent complaint review board, separate from the court administrator's office, with authority to investigate citizen grievances and refer findings directly to the Judicial Conduct Commission. Third, we recommend quarterly statistical audits of case outcomes, broken down by race, income level, and representation status. Any pattern showing disparate treatment would trigger automatic review by the independent board. Fourth, we recommend elimination of financial performance metrics for judicial evaluations. Judges should be evaluated on procedural compliance and case quality, not on conviction rates or revenue generation. The commissioners listen. Some nod, some frown, some wear the carefully neutral expressions of elected officials calculating political implications. Rosa Delgado watches from the gallery. She's heard promises before, seen reforms announced and never implemented, watched systems promise change and deliver nothing. But something feels different this time. Maybe it's the federal investigation looming in the background. Maybe it's the media attention that hasn't faded. Maybe it's the simple fact that a Supreme Court justice experienced what ordinary citizens experience, and the story went national. Or maybe it's just hope. The stubborn, irrational hope that keeps people fighting systems even when systems always seem to win. Commissioner Harrison clears his throat. These are significant recommendations. Implementation will require substantial resources, new recording equipment, staff for the independent board, training for revised procedures. What's the projected budget impact? Approximately $400,000 annually, Attorney Okonkwo responds. However, the county's current exposure to civil liability from the documented misconduct is substantially higher. The Rodriguez family has already filed suit. The Patterson family is considering similar action. If the federal investigation results in pattern or practice findings, the county could face DOJ oversight and mandatory reforms that would cost significantly more than voluntary compliance. So this is damage control. This is accountability, Chairman. Damage control would be hoping the investigations go away. What I'm recommending is structural change that prevents future misconduct, reduces legal exposure, and restores public trust in our court system. The commissioners exchange glances. The political calculation visible. Vote for reform and appear responsive to public pressure. Vote against and appear complicit in the scandal still dominating local news. The vote is 5-2 in favor of the reforms. Rosa Delgado watches the hands raise, watches the chairman announce the result, watches the first real structural change she's seen in 6 years of fighting. It's not enough. Won't fix everything. Won't undo the damage already done to hundreds of citizens who were denied justice. But it's something. She gathers her file boxes, walks out of the meeting room, calls Vivian Marlowe on the drive home. They passed it, all 4 recommendations. Implementation will be the hard part. I know. But they passed it. They actually passed it. A pause on the line. When Vivian speaks, her voice carries something that sounds almost like satisfaction. That's how change happens, Ms. Delgado. Not all at once, not perfectly, but one vote at a time, one reform at a time, one small victory that makes the next victory possible. You really believe that? I have to believe it. The alternative is accepting that systems are permanent, that power always protects itself, that the people at the bottom never win. Another pause. I've spent 40 years watching systems change. It's always slower than it should be. It's always more incomplete than we want. But it happens. When enough people refuse to accept the unacceptable, eventually the unacceptable becomes impossible. Rosa thinks about the 62 cases in her file boxes. About the hundreds more she knows exist but hasn't documented yet. About the citizens who were laughed at, dismissed, removed, denied. Some of them won't live to see it. No, some of them won't. Mr. Patterson is 73 years old. His case was 4 years ago. If Briggs appeals for the maximum time allowed, Patterson might not be alive when the final resolution comes. That's not justice. No, it's not. Justice delayed is justice denied. But justice delayed is also justice not forgotten. The record exists now. The pattern is documented. The system can't pretend it didn't happen. Is that enough? It's never enough. But it's something. And something is what we build on. The federal investigation continues through the winter and into the spring. Vivian follows it from Washington, receiving periodic updates from Marcus Webb, reading the news coverage that gradually expands from local interest to national significance. The story has legs: a Supreme Court justice experiencing discrimination in traffic court, a network of corrupt judges and administrators, political connections reaching to the state attorney general's office. The kind of story that captures public attention because it confirms what everyone suspects but rarely sees proven: that the system is designed to protect itself, that the powerful play by different rules, that justice for the poor looks nothing like justice for the privileged. In February, Attorney General Morrison announces he will not seek re-election. The official statement cites family considerations and a desire to pursue opportunities in the private sector. The unofficial reality is that the DOJ investigation has made his position untenable. He can't run for re-election while potentially facing federal charges. He can't continue in office while his staff is being subpoenaed and his donors are being investigated. He exits gracefully, the way powerful people always exit, with statements of accomplishment, with well wishes from colleagues, with a soft landing in a prestigious law firm that will pay him twice his government salary to do half the work. He's never charged. The evidence of his direct involvement never materializes. The intermediaries who might have testified against him negotiate their own deals, trading cooperation for leniency, protecting themselves at the expense of complete accountability. The system protects itself, even when it can't protect everyone. But the investigation continues. 11 months after the commission hearing, the DOJ announces formal findings. The Department of Justice has concluded its investigation into municipal court operations in Marlow, Clayton, Fulton, and DeKalb counties, Georgia. The investigation, conducted pursuant to 42 U.S.C. Section 14141, finds reasonable cause to believe that these court systems have engaged in a pattern or practice of conduct that deprives persons of rights protected by the 14th Amendment to the United States Constitution. Specifically, the investigation finds that these court systems have systematically denied due process to pro-SE litigants, imposed disparate penalties based on race and socioeconomic status, suppressed citizen complaints, and prioritized revenue generation over fair adjudication. The department is prepared to file suit seeking injunctive relief unless the affected jurisdictions agree to enter into consent agreements providing for comprehensive reform and federal monitoring. Federal monitoring. Court-ordered reform. The machinery of civil rights enforcement finally engaged. Vivian reads the announcement in her chambers, reads the detailed findings that echo what she experienced, what Rosa documented, what 62 citizens in Marlow County alone testified about. The system is being held accountable, not perfectly, not completely, but meaningfully. She calls Rosa Delgado. "You saw the announcement?" "I saw it." Rosa's voice carries something that might be tears. 11 years. 11 years of documenting, filing, testifying, being ignored. And finally someone listened. Someone with a federal badge and subpoena power. That too. Vivian pauses. But it started with documentation, Ms. Delgado. It started with you and Mr. Patterson and everyone else who refused to let the pattern go undocumented. The DOJ investigation succeeded because you built the foundation they could build on. That's generous. It's accurate. Federal investigators don't start from scratch. They start from the work of people who've been fighting the fight for years. Your 62 cases, 62 documented examples of the pattern they proved. Without that documentation, they'd have had nothing to investigate. A long pause. What happens now? Now the jurisdictions decide whether to consent or fight. If they consent, they agree to federal monitoring, outside oversight of their court systems, mandatory reforms, regular compliance audits. If they fight, the DOJ files suit, and the whole process plays out in federal court for years. And if they consent, then reform happens, slowly, imperfectly. But it happens. The consent agreements require specific changes, recording requirements, independent oversight, statistical monitoring. The federal monitors enforce compliance. The jurisdictions that try to backslide get caught and face additional consequences. For how long? The monitors, usually 5 to 10 years, long enough to institutionalize the changes, long enough that a new generation of court administrators grows up under the new rules and doesn't know any other way. That's a long time. Yes, it is, but it's also a long time for things to go right, a long time for citizens to receive fair treatment, a long time for the pattern to stay broken. The system is finally being held accountable, but some threads never get resolved, some questions never get answered. Marlow County consents to federal monitoring in March. The consent agreement is 43 pages of specific requirements, recording mandates, oversight structures, training protocols, statistical benchmarks. The federal monitor, a retired federal judge named Helen Okonkwo, no relation to the county attorney, will review compliance quarterly and report to the DOJ. The other 3 counties consent within weeks. The political calculation is clear. Fighting the DOJ would be expensive, prolonged, and ultimately futile. Better to accept oversight and claim credit for reform than to resist and appear complicit in the scandal. The consent decrees will remain in effect for 7 years. 7 years of federal oversight. 7 years of mandatory compliance. 7 years during which the system can't backslide into the patterns that served it so well before someone with power experienced what powerless people experience every day. It's not permanent change. Systems have memory. Institutional culture persists even under external pressure. When the monitors leave, when the consent decrees expire, when the scandal fades from public memory, the pressure toward old patterns will return. But 7 years is something. 7 years of citizens receiving fair treatment. 7 years of complaints being investigated rather than buried. 7 years of precedent that can be pointed to when the next scandal erupts. Small victories, incremental progress, the way change actually happens. Harrison Vance is indicted in April. 11 counts of wire fraud, 8 counts of conspiracy to violate civil rights, 3 counts of obstruction of justice. The indictment runs to 47 pages, detailing the financial scheme that connected Judicial Efficiency Partners to Piedmont Holdings to the county court systems that processed citizens for profit. His brother Felix testifies at the trial, takes the stand, faces the jury, explains how the system worked, how judges were recruited, how complaints were buried, how the money flowed from citations to consulting fees to real estate investments, testifies against his own brother in exchange for a reduced sentence. The trial takes 3 weeks. The jury deliberates for 2 days. Guilty on all counts. Harrison Vance is sentenced to 17 years in federal prison. The judge, not Briggs, not anyone from the network, but a federal district judge from the Northern District of Georgia, delivers the sentence with words that will be quoted in legal journals for years. The defendant did not merely steal money, he stole justice. He designed and implemented a system that extracted wealth from the most vulnerable citizens while denying them the constitutional protections to which every American is entitled. The financial crimes are serious. The civil rights crimes are more serious still. The sentence reflects the gravity of both. 17 years. Not enough, some will say. Others will point out that it's more than most white-collar criminals receive, more than most civil rights violators face. Vivian reads about the sentencing in her chambers, reads the judge's words, thinks about the 62 citizens in Marlow County, the hundreds more across 4 counties, the thousands more across the country who experience similar patterns in courts that haven't been investigated yet. One case, one network, one set of convictions. Not enough, but something. Felix Vance receives his sentence 2 months later. 4 years in federal prison, reduced from the 15 to 20 he would have faced without cooperation. Eligibility for early release after 3 years with good behavior. The sentence is controversial. Advocates argue it's too lenient. Felix enabled the system for years, buried complaints, protected corrupt judges. Prosecutors argue it's appropriate. His cooperation was essential to building the case against his brother, against the network, against the entire scheme. Vivian doesn't have an opinion she shares publicly. Private citizens deserve their due process. Convicted criminals deserve their sentences. What happens between those 2 points is for prosecutors and judges to determine, not for Supreme Court justices to second-guess. But she thinks about the meeting in Atlanta, the conference room where she'd explained his options, the choice she'd offered between cooperation and consequences. He'd chosen cooperation, and cooperation had brought down the network. Not entirely, not perfectly. Some of the judges retired before charges could be filed. Some of the administrators negotiated plea deals that minimized their exposure. Some of the political connections were never proven to the standard required for prosecution. The system protected itself, partially, the way it always does. But less than before. Less than it would have if no one had documented the pattern. Less than it would have if a Supreme Court justice hadn't experienced discrimination in traffic court and decided to fight back. A year after the commission hearing, Vivian receives a letter. Different handwriting from the anonymous note she'd received before. Same lack of return address. Same Marlow County postmark. She opens it in her chambers, the spring light falling through the windows. Justice Marlow, I was the clerk who processed your case on May 14th. I moved your hearing from 9:30 to 11:15 because my supervisor told me to. She said you were a troublemaker who needed to wait and cool down. I knew it was wrong. I did it anyway. I've thought about that every day since, about all the cases I processed the same way, about the citizens whose time I wasted because my supervisor told me to, about the pattern I was part of without ever questioning it. I resigned after the commission hearing, couldn't do it anymore, couldn't pretend I didn't know what we were doing. I'm working at a nonprofit now, helping people navigate the court system, helping them understand their rights, trying to make up for the rights I helped deny. I don't know if it matters. I don't know if anything I do now can undo what I did then, but I'm trying. I wanted you to know that someone is trying. The clerk who moved your case. Vivian reads the letter twice, 3 times. Then she folds it carefully, places it in the folder where she keeps the documents from the Marlow County case. The complaints, the evidence, the anonymous notes from people inside the system who decided that conscience mattered more than career. One more person trying to do better. It's not systemic change. It's not justice, but it's something. The story doesn't end. That's what people don't understand about cases like this, about systems like this, about the long, slow work of making institutions accountable. There's no final scene where everything is resolved. No moment where justice is complete and the credits roll. The dominoes keep falling. The consequences keep cascading. The system keeps adjusting, resisting, partially reforming, partially reverting. Judge Briggs's appeal works its way through the courts. 2 years after the Commission's final report, the State Appeals Court upholds the finding. Briggs appeals to the State Supreme Court. They decline to hear the case. His removal is final. He never faces criminal charges. The statute of limitations on most of the civil rights violations has expired. The evidence of specific incidents is strong, but the evidence of criminal intent is harder to prove. The district attorney's office closes its investigation with a statement about insufficient evidence to proceed. He lives out his retirement in a suburb of Atlanta, collects whatever pension wasn't forfeited, gives no interviews, makes no public statements, disappears into the particular anonymity of people who were powerful and aren't anymore. Some call it justice. Some call it escape. Some call it the inevitable outcome of a system that was never designed to hold its own accountable. Sergeant Pace's termination is upheld after 18 months of appeals. He files a civil lawsuit claiming wrongful termination. The lawsuit is dismissed. He takes a job as a private security guard at a shopping mall 2 counties away. Trent Lawson's State Bar Review concludes with a public censure and 3-year suspension of his license. He can practice law again in 2028. Whether anyone will hire him remains to be seen. Felix Vance serves 3.5 years of his 4-year sentence, released to a halfway house, then to probation, then to freedom of a kind. His brother Harrison serves 11 years of his 17-year sentence. Good behavior, overcrowded prisons, the mathematics of incarceration that apply to everyone, including the architects of systems designed to incarcerate. The federal monitors remain in Marlow County for the full 7 years. Quarterly reviews, compliance audits, statistical monitoring that shows the pattern of disparate treatment declining but not disappearing. Progress, partial, imperfect. The way progress always is. Rosa Delgado continues her work. The file boxes that once held 62 documented cases now hold hundreds. New cases from other jurisdictions, other patterns that need documenting, other systems that need challenging. She becomes a name in civil rights circles, gets invited to conferences, testifies before legislative committees, writes reports that get read by people who can make decisions. The work is slow. The results are incremental. The system pushes back at every step. But she doesn't stop. Can't stop. The work is the work, whether anyone's watching or not. Mr. Patterson dies in the spring of his 78th year. Natural causes, old age, the particular winding down that comes to everyone eventually. He never sees the final resolution of Judge Briggs's appeals, never sees the consent decrees expire and the federal monitors leave, never knows whether the reforms will stick or whether the system will revert to the patterns he spent his last years fighting. But he knows the pattern was documented, knows his case was part of the record, knows that 62 citizens stood together and demanded accountability from a system that had ignored them for years. Rosa Delgado attends his funeral. Vivian Marlowe sends flowers and a personal note to his family, a note that thanks him for his courage, his persistence, his refusal to accept what the system told him he had to accept. One life, one case, one small piece of a pattern that added up to something larger than any individual. That's how change happens. Not in the victories of heroes, in the persistence of ordinary people who refuse to give up. 3 years after the commission hearing, Vivian Marlowe writes an opinion. Not about Marlow County, not about traffic courts or municipal justice or the specific case that started everything, but about due process, about the 14th Amendment, about what the Constitution requires when citizens face government authority. The case is about a different court in a different state. A litigant denied the opportunity to present evidence. A judge who prioritized efficiency over fairness. A pattern that mirrors what she experienced in ways the lawyers arguing before her don't know. Her opinion becomes the majority opinion. 5-4. The kind of close decision that could have gone either way if different justices had different experiences. The key passage is quoted in legal journals for years. Due process is not a luxury reserved for those with resources. It is not a privilege extended to those the system deems worthy. It is a constitutional requirement that applies in every courtroom in this nation, from the Supreme Court to the most humble traffic court in the most neglected jurisdiction. When courts prioritize efficiency over fairness, when judges deny citizens the opportunity to be heard, when the machinery of justice becomes a tool for revenue rather than a forum for rights, the Constitution is violated. Not in dramatic fashion, not in ways that make headlines, but violated nonetheless, one citizen at a time, one case at a time, one small injustice compounding into a pattern that denies millions of Americans the process they are due. This court will not countenance such patterns, not in this case, not in any case that comes before us. The promise of equal protection is not kept in grand pronouncements, but in ordinary courtrooms, where ordinary citizens seek nothing more than the chance to be heard. The opinion cites no personal experience, makes no reference to Marlow County, maintains the judicial propriety that separates the justice from the citizen. But everyone who knows the story recognizes what shapes those words. The system doesn't change overnight, but it changes. One case at a time, one person at a time. One small victory that makes the next victory possible. 5 years after the commission hearing, Vivian Marlow drives through Marlow County. She's not appearing in court this time, not documenting patterns, not testifying before commissions, just driving through, the way any citizen might, on the way to somewhere else. The courthouse looks the same. Concrete and brick. Parking lot half full. Citizens walking in with their papers and their hopes. She doesn't stop, doesn't enter, just drives past, the building visible through her window for maybe 30 seconds before it disappears behind her. Inside that building, a different judge sits on the bench in courtroom 3B. The recording system captures every word. The independent oversight board reviews complaints quarterly. The statistical audits show outcomes that, while not perfect, no longer show the stark, disparate treatment that characterized the Briggs era. The consent decree expired last year. The federal monitors filed their final report. Compliance achieved, reforms institutionalized, oversight transferred to state authorities. Whether it lasts remains to be seen. The pressures that created the original pattern haven't disappeared. Budget constraints, caseload pressures, the temptation to process cases faster at the expense of fairness. But the record exists. The precedent exists. The documentation of what happened and how it was challenged. That exists too, in legal databases and news archives and the memories of people who lived through it. The next time someone tries to build a system like Briggs's system, they'll know it can be challenged. They'll know someone documented the pattern. They'll know that a Supreme Court justice once stood in a traffic court without credentials, experienced what ordinary citizens experience, and fought back. They'll know the system isn't invulnerable. That's something. Not everything, but something. The sun is setting as she drives west, the Georgia sky streaked with orange and purple. Her phone sits silent on the passenger seat. No urgent calls, no breaking developments, just the road and the fading light and the particular peace that comes from knowing you did what you could with what you had. Not enough, never enough, but something. She drives on. Chapter. That night, in a small office in downtown Atlanta, a woman sits at her desk reviewing files. Her name is Keisha Washington. 4 years ago, she was a young mother with a traffic citation, sitting in Judge Briggs's courtroom, watching a woman in a gray cardigan get laughed at and removed. Now she's a paralegal at Rosa Delgado's nonprofit, one of dozens who've joined the organization since the Marlow County case made national news. Young people mostly, idealistic, angry, determined to document the patterns that others ignore. On her desk, files from 3 counties in Alabama. Similar patterns to what they found in Georgia. Similar buried complaints. Similar disparate treatment. Similar work to be done. She opens the first file, reads the first complaint, notes the pattern beginning to emerge. The woman who wrote this complaint is 71 years old, filed it 3 years ago, never heard back. Keisha picks up her phone, dials the number on the complaint. An elderly woman answers. Mrs. Jackson, my name is Keisha Washington. I'm calling about a complaint you filed against Judge Harrison in Talladega County. I know it's been a long time. I know you probably thought no one was listening, but I'm listening now, and I want to hear your story. The work continues, one case at a time, one pattern at a time, one small victory that makes the next victory possible. The system doesn't change overnight. The system doesn't change completely. The system doesn't change without resistance, without setbacks, without moments when it seems like nothing will ever be different. But it changes. Because people refuse to accept the unacceptable. Because people document the patterns that others ignore. Because sometimes, not always, not often enough, but sometimes, someone with power experiences what powerless people experience, and the system is forced to respond. Vivian Marlowe sits in her chambers in Washington, reviewing cert petitions, the work of the court continuing around her. Rosa Delgado sits in her office in Atlanta, reviewing new cases, the work of advocacy continuing around her. Keisha Washington sits at her desk, talking to an elderly woman in Alabama who thought no one was listening. The phone calls continue. The documentation continues. The work continues. Not enough. Never enough. But something. Always something. In the Marlowe County Courthouse, a young black woman approaches the podium in courtroom 3B. She's nervous. This is her first time in court. She has a folder of documents, evidence that the parking ticket she received was issued incorrectly, that the sign was obscured, that she shouldn't have to pay. The judge, not Briggs, a different judge, a younger judge, looks up from the bench. Ms. Williams, you're appearing pro se today? Yes, Your Honor. I see you have some documents. Would you like to present them? She hesitates, waits for the dismissal, waits for the laughter, waits for someone to tell her that her evidence doesn't matter, that she's wasting the court's time, that knowing the law doesn't make her a lawyer. The dismissal doesn't come. Take your time, Ms. Williams. The court is listening. She begins to speak. The recording light blinks green, capturing every word. The case proceeds. Justice, imperfect, incomplete, but present, is served. The end. Somewhere, in a courthouse no one is watching, the pattern is starting again. New judges, new administrators, new systems designed to process citizens rather than serve them. But somewhere else, someone is documenting, someone is filing, someone is refusing to accept what the system says they have to accept. The story doesn't end. It never ends. It just continues. One case at a time, one person at a time, one small victory that makes the next victory possible. Until the next time the system laughs at someone it shouldn't have laughed at, and discovers, too late, who they were really dealing with.